Hello, welcome to Live at Lunch. In today's episode, we are talking about alternatives to the H-1B visa classification. And specifically today, we're talking about green card-based alternatives. Before we get to that though, I want to share with you some breaking news. We have data from USCIS that was sent just a few minutes ago, earlier this morning, on the number of registrations and selections for the H-1B cap. So I'm going to bring up the email and share that information with you. So USCIS says that for this fiscal year, for the fiscal year 2025, which is this year, despite what the name implies, for this year's registrations, USCIS received approximately 442,000 unique beneficiaries this year. That was about the same as last year. Last year was about 446,000 unique beneficiaries. Remember, the number of registrations last year, which was much higher, it was almost 800,000, but that's because they were duplicate entries. So there were foreign nationals who were entering or being entered and registered in the lottery multiple times through multiple employers. This year, remember, we have a significant change in the selection system. The selection system was beneficiary centric. That means that the selections were made based on the foreign nationals' passport numbers, unique passport numbers, rather than the individual employers. The number of unique employers this year was about 52,700, also similar to last year, which was about 52,000. But the number of eligible registrations for this year was significantly down from last year. So, and this is where the difference comes in, the number of eligible registrations. This year was about 470,342 versus 758,994 last year. So that's per USCIS, I haven't done the math, a 38.6 reduction. Last year they saw, or this year rather, they said that there was an average of 1.06 registrations per beneficiary compared to 1.7 last year. So I think that this is encouraging. Certainly the system has its ways that it could be made better, areas for improvement, certainly. But I do think that it is an improvement over last year in that the beneficiary-centric selection process seems to have really cut down on the number of duplicate registrations, and the overall selection, it seems, is higher, at least for this first round. We do not know at this point if there will be a second round for the lottery. USCIS has to see, of the number of people that were selected, how many of those actually submit H-1B petitions. I personally think that there will not be a second round, but who knows? We will know later this summer, probably, if there's going to be a second round, or USCIS will announce that the cap has been met and that there will not be a second round. So stay tuned for that information. In the meantime, for those individuals who are not selected in the H-1B lottery, have heard there are options beyond the H-1B that you should definitely be looking into. In our last Live at Lunch, which was week before last, wasn't feeling well last week, but last Live at Lunch, we talked about the non-immigrant visa classifications, some of them that might be alternatives to the H-1B. In this video, we're talking about green card-based alternatives. I want to start by saying that several years ago, this was something that we were recommending pretty regularly to individuals not selected in the H-1B lottery as a pretty realistic option, depending on your particular situation, depending on, we'll talk about this, but the country that you were born in, what your current immigration status is. It was a realistic possibility to have the employer start the green card process, or perhaps file one of the self-sponsored petitions and be able to stay in the United States that way and work potentially without interruption in your work authorization. Realistically, that has changed, not completely, but that has changed for a couple of reasons. One is depending on the employment-based process that you're going through. If you're going through the perm labor certification process, that process is taking significantly longer now. The processing times at Department of Labor are obscenely high, obscenely long, and they're much longer than they were even a few years ago. So we have clients who have started the green card process 2 or 3 years ago, thinking that they would be able to get through this process. And we told them that they would likely be able to get through this process based on current processing times, which are always subject to change. But they were thinking that they could get through the process and potentially have the green card or at least the employment authorization document. And that may not be the case. It really is not the case as often because of the perm processing times and because of the visa bulletin situation. So I have another video on the visa bulletin, kind of the explanation of what the visa bulletin is and what a priority date is and how to read more or less the visa bulletin. I'll drop the link to that in the comments. But know that the visa bulletin is the document that the Department of State publishes once a month to tell us more or less when a green card might be available for a person. And the availability of green cards has decreased in general. That's a blanket statement and of course does not apply to every single classification, but in general, across the board, the availability of green cards has really slowed down, which in turn slows down the process. There has to be a green card available in order for your green card application, for your particular classification, in order for your green card to be approved. So between those two, between the Department of Labor processing times and the visa bulletin, the green card options have become maybe less of a viable option. I'm not saying don't do it. I'm not saying don't look into it, but it has changed. If you talk to friends who did this a few years ago and they say, oh yeah, I got my green card in 2 years, that might be, and it may or may not be the case for you depending on your specific situation. So what are some things to look into? What are some things to consider? One is keep in mind that this may still be an option for you, but be flexible. Know that these processing times change all the time and that these processing times could change for better or for worse. Think about which employment-based green card classification you might be eligible for. Everyone in the world wants to qualify for the EB1 classification, which is the first category. Everybody wants to qualify for that because a green card is generally available faster in those particular categories. So it's understandable that people would want to qualify. There are three subcategories, or there are three subcategories within the EB1 classification. EB1A, which is for foreign nationals of extraordinary ability, EB1B, which is for outstanding researchers and professors, and EB1C, which is for multinational executives and managers. There are certain qualifications for each one of these categories that you have to meet, and USCIS has a lot of discretion to approve these cases, especially where the Kazarian analysis applies, which is the EB1A and the EB1B classifications. So know that even if you look at the criteria and you think, oh, I easily meet 3 of those or however many it is of those criteria, that does not necessarily mean that this is a good plan for you. Please talk to a qualified immigration lawyer before you invest in this process. So think about which classification you might be eligible for. Then think about, based on that classification and based on your country of birth, how long might it take to get a green card? And then think about how much time do you actually have left, either in your current status. Let's say that you're on the first 12 months of OPT right now, and you're planning to do a STEM extension. That's great. But the STEM extension will get you another 2 years. Is that enough time realistically to get you from the point of starting the green card to the point of actually having the green card, or having at least the employment authorization document that is an interim benefit as part of the green card process? So those are things that you should be thinking about. As I mentioned, I have a separate video on the visa bulletin classification, or the visa bulletin, and kind of how to read the visa bulletin. Okay, I'm not going to share my screen right now, but know that there's a separate video that I'll link in the comments on how to read the visa bulletin. So if you're eligible for the EB1A right now, or at least in the month of May, the EB1 classification is current if you were born in a country other than China or India. If you were born in China or India, there is going to be somewhat of a wait for the green card. Most people will not qualify for the EB1A classification, and that's okay. It doesn't mean that it's the end of the world and you have to pack your bags and go home. But know that if you fall into the EB2 or EB3 category, that it might be a bit of a longer wait. It will be a bit of a longer wait. So for example, the priority date for The rest of the world for EB2 is for May is January 15th, 2023. I'm looking at the final action dates. So that means you might have to wait a bit before you actually apply for the green card or before you're able to apply for the I-485. And that might be okay if you have another couple of years left on STEM OPT, or if you plan to go back to school, for example, and pursue another degree while the green card process is playing out. I think I've mentioned on previous videos that I have a number of clients who were here on OPT, for example. Their employers started the green card process and then they went back to their home country in order to finish out, wait out the rest of the green card process. And that's an okay option as well. Ultimately, they either have already come back or they will come back and ultimately get to where they want to be. But they, for whatever, for various reasons, have gone home in the meantime. So think about what employment-based category you might be eligible for. Think about how long that process is realistically going to take. And remember, you have to consider government processing times as well as the wait for the green card, looking at the visa bulletin. In addition, you have to think about how long is it going to take to prepare this application, whether you file it on your own or you file it using the services or working with an immigration attorney. Even if you decide, all right, I was not born in NDR, China. I'm going to file an EB-1A petition. I'm well qualified. I'm going to get this filed. Think about how much time you have left in whatever your current immigration status is, because it takes a hot minute to use a colloquial term to prepare that application. There's a lot of work that goes into it, and it's not something that you can turn around overnight. So think about how much time you will realistically need to prepare the application as well, or the petition as well, in addition to government processing times and the visa bulletin. Think about other categories as well. So like I said, not everybody is going to qualify for the EB-1A or any EB-1 category. It is possible that you may qualify for the national interest waiver classification, which falls into the EB-2 category. That's another one that lots and lots of people are asking about. It's been kind of trendy for the past couple of years. Again, just because you are, another person, let's say, who has the NIW approved, that's great for them. It may or may not be appropriate for you. So make sure that you get qualified or good quality legal advice before you invest in that process. Again, not saying don't do it or don't look into it, but you want to make sure you have a realistic chance or at least know the level of risk that you're taking if you decide to proceed. Family-based options are a possibility as well. I think I've mentioned in previous videos that almost every year I have a client who was not selected in the H-1B cap, and we talk about their options and they say, oh, well, what about a marriage-based case, for example? And it has to be a valid relationship, of course. It cannot be for immigration purposes, but the clients that I've talked to they have been in a long-term committed relationship. They're planning on getting married anyway, and they pursue that option. So know that that is a possibility. Honestly, that process is one of the faster processes that is available to you. Again, it has to be a true relationship. It has to be a bona fide relationship and not just for immigration purposes. Sometimes people will ask me about other family-based options, like having their parent file for them or having their sibling file for them. That could be a possibility, but take a good look at the visa bulletin and have a conversation if you need to with an immigration lawyer about realistic timelines for that. Having your US citizen sibling sponsor you for permanent residence is not the solution to not being selected for the H-1B. Regardless of the country that you were born in, it is going to be a very long wait, like years and years. We're talking about like 10, 12, 15 plus years before a green card is available for you. And just having filed that I-130 petition is not enough to allow you to stay in the United States, does not give you the ability to work. So that might be a potential long-term tactic that you want to consider, but it is not an immediate solution for not having been selected in the H-1B process. Same if you have a parent who is a US citizen or a permanent resident and who could potentially file for you. It's not going to take that long probably, but it will take a number of years for a green card to become available, and it's not an immediate solution. So those are the green card options or the permanent residence alternatives. Like I said, it has changed. The landscape has changed in the past couple of years. So if you talk to people who did this successfully, maybe 2 or 3 years ago, as recently as 2 or 3 years ago, know that things are not the same now in terms of processing times and green card availability as they were a couple of years ago. And your options might look different. Again, that doesn't mean don't explore it, but just keep in mind that things change over time and your experience is not going to be exactly the same as your friends, whoever you talked to about the process. So I hope that you have found this information useful. And next week in our Lunch at Live, I always get that wrong, Live at Lunch next week, next Tuesday at noon, we will be talking about H-1B alternatives. It's the last in this particular series, and talking about working overseas temporarily and different strategies that are available there. So I hope that you will join us. I hope that you have found this information helpful, whether you joined us live or caught the replay. Make sure that you subscribe to this channel, whichever platform you're watching this on, to make sure that you don't miss the next video in this series and others beyond that. Let me know if you have questions. Send an email to info@sumnerimmigration.com if we can be of assistance, and we look forward to hearing from you. Until next time, I'm Emily Sumner with Sumner Immigration Law, based in Richmond, Virginia, and helping clients with employment and family-based matters throughout the United States and around the world. Until next time, take care.